Based in Sacramento, Dr. George Jouganatos has been a college lecturer for 35 years. He has taught economics, finance, management, ethics, and quantitative analysis at the University of California, Davis, University of California, Santa Cruz, California State University, Sacramento, and the University of San Francisco. Dr. Jouganatos is in demand as an expert witness for cases involving personal injury, wrongful death, wrongful termination, employment discrimination, economic loss, business valuations, lost profits, and divorce. He has consulted and given testimony for numerous attorneys in California, as well as in New York, Nevada, Ohio, Pennsylvania, and many other states. He has consulted in approximately 1,000 cases and for more than 225 law firms. He regularly provides commentaries on economic events and issues for television, radio, and print media, and has conducted numerous MCLE courses, public lectures, and seminars.
Hello, thank you for attending Economic Analysis and Employment Cases. So please pay attention. There's many important aspects that I shall be covering. First, an overview. I'll be covering compensatory damages. These include loss of earnings, all forms of compensation, both past and future. Benefits will be discussed, such as health benefits, and pension. I'll also discuss Social Security issue. Social Security is usually not relevant in employment cases. Then I'll be discussing the calculations, historic loss or back pay, and present value of future loss or front pay. The main components of the calculations include work life, discount rate or net discount rate, wage growth rate, salary or compensation basis. Then I'll delve into pension, health benefits, and a little bit more discussion on Social Security, unused vacation. Also, a important and substantial topic is mitigation of loss. Some discussion of taxes will follow, and then punitive damages would be discussed briefly, why they may come up, for instance, and as well as credit score damage. Historic loss is the period of time from the incident, such as wrongful termination or denial of promotion, to date of trial. If there isn't a trial date, we can choose a hypothetical date. It could be also a mediation date or a settlement date, but normally we may estimate a date of trial, but we have to have some sort of date to demarcate between historic loss or back pay and front pay or present value of future loss. Wage growth rates could be used to increase the wage from the moment of the incident to trial date. These wage growth rates could be obtained from the other party, the employer, that is, or we could use national averages, which are acceptable. There's also possibly, and I've done this numerous times, to include some adjustment for lost chance or promotion. They could have been denied promotion. We want to include promotion in our analysis. Not always was promotion involved, but sometimes. So we may want to include a scenario when a promotion could have been granted, as well as a scenario where a promotion was not granted. Anyhow, so back pay may be increased, take into consideration promotions that the employee was likely to receive. Present value of future loss or front pay, that takes us from the point of trial could be trial conclusion or beginning of trial, it doesn't matter much, to the end of work life. And what we're looking at is discounting this future stream of compensation, whether it's earnings or benefits. What we're doing is we're discounting this future stream of earnings and bringing it to our present day. That's a must. Discounting is a requirement, really. And what we're saying is that $1 a year from now has a lower value today. Now, there is case law that substantiates our need to consider loss for the remainder of work life. And you can see some of the case law on page 2 of the outline. Now, another consideration, of course, is to allow for losses to extend to the full age retirement Social Security. Usually, I may include full retirement age in Social Security if it's a little bit older worker, but we have to include work life, that's for sure. I'll come back to work life shortly. Now, this discounting is discussed on page 3 with a hypothetical example. We have in this hypothetical income of $10,000 a year for 3 years, and I give you the growth rate of wages, 3.65%, and a discount rate of 5%. And the net discount rate, therefore, is 5 minus 3.65. So the net discount rate is 1.35. What you need to consider is that the higher the net discount rate, the lower the present value. For that matter, the higher the discount rate, the lower the present value. The higher the wage growth rate, the higher the present value. I'll come back to these as well. But what we are saying here in this hypothetical, that the $10,000 a year for 3 years, given our net discount rate of 1.35, comes to, in the present day, a little bit over $29,000. Now back to the main components of the analysis. Work life is a statistical average of the number of years a person will be working. It factors out the probability of leaving the workforce due to illness, child rearing, God forbid, death, and leaving the workforce for whatever reason. It could be a temporary, could be parental leave, whatever the case might be, is exiting the workforce temporarily. Now, the original work-life expectancy tables appear to have been sourced by Bureau of Labor Statistics, but they're outdated, and we still use BLS, Bureau of Labor Statistics, data to compute work-life tables, and there's a small handful of authoritative, peer-reviewed work-life tables. On page 4, I discuss the top of page 4. I discuss the work-life table that I use. And it was updated since then. So I'm using the 2019 version of this article, peer-reviewed article that you see on the top of page 4. We can also use, like I said, the full retirement age of Social Security to extend losses further. The discount rate, and by the way, the different work-life tables that exist out there, there's not too many, as I stated, appear to give us the same number of work-life years overall. They're closely matched. Now, the work-life tables that I use take into consideration gender, and education levels. So going to the discount rate now, I use a discount rate presently of 2.644%. And this is a combined average annual yields of treasury bonds, 3-year, 5-year, 7-year, 10-year treasury bonds. We usually must use risk-free type of discount rate for, let's say, employment cases, personal injury cases, but for business cases, no, we don't use risk-free. Anyhow, what we mean by risk-free is default risk-free. The United States government is not going to default on our treasuries. To continue, for a number of years now, I've been using treasury bonds, but prior to that, I was using treasury bills, okay, because those are short-term and even more risk-free in terms of inflation risk-free, okay. But I've turned to bonds because they offered a higher yield. Right now, though, treasury bills are back to their normal. So it's okay to go back to using treasury bills. Ultimately, there's a wide latitude among experts and even in the courts as to the discount rate. So it's not such a big deal, in my view. Wide latitude is given, and as I state towards the bottom of the page, there's much ado about nothing in terms of discount rate controversy. What's most important really is the net discount rate, which is the discount rate minus the wage growth rate. So again, I give you some discussion that there is a good amount of leeway amongst the parties involved regarding the discount rate. Usually we don't have too much critique amongst experts on the discount rate. I give you some court cases as well as what we refer to as peer-reviewed literature in litigation economics to substantiate, for instance, using a long-term average, which is what I do. I use a long-term average of 20 years. I've been doing that probably from the beginning. I've been at it for 30 years as an expert witness. So in the past, when I was using treasury bills, I was still using a 20-year average of treasury bills. Now I'm using a variety of treasury bonds, and I'm using a 20-year average for each of these treasury bonds, and then I combine them. To continue now, growth rate of salary. I'm at Roman numeral 5 in the outline. So again, the higher the growth rate, the higher the present value of future earnings. Again, I use a 20-year average. We need to be consistent. Our discount rate and wage growth rate need to be matched consistently. If you're using a 20-year average discount rate, you must use a 20-year average. Well, it makes sense to be consistent. And I say must, well, in my view, it is a must. So 20-year average wage growth rate. So in the private sector, non-agricultural, it is 2.525, and in the public sector, 2.25. For the federal government, it's 2.443, again, a 20-year average. So those are the wage growth rates, private sector, public sector. Public sector would be state and local government, and federal government. Often these historic national averages, I mean, ideally, if we have the data and we're given the time to obtain the data, for instance, from the employer or through other sources, ideally, it'd be to look at the salary schedules from one year to the next year to the next year. And often in the public sector, we can find those salary schedules. But in lieu of that, we can use national averages, and that's acceptable. Often this historic national average might be below the plaintiff's wage increases. As I point out on the top of page 7, the unfortunate reality is for the average American, wage growth rate has not been keeping up with inflation on average since 1975. This can be referred to as the phenomenon of the falling real wage. Using inflation rate, therefore, might overstate the loss. Using wage growth rate is more conservative and perhaps more astute, as an opposing expert once mentioned. To continue, let's go to salary base. Again, in our salary base, we could use the last salary that the plaintiff was earning, I should say, and make certain adjustments if needed. But we do typically look at specific earnings history of the plaintiff and exercise some judgment in determining the earning capacity that should be expected in the future years. So there are articles in peer-reviewed journals that are part of the National Association of Forensic Economists that we can review and help us. But no matter what, we do examine past earnings, and that can help give us some initial basis of salary loss. Salary and generally compensation differentials are used as annual compensation basis in computing losses for employment matters. So again, if the person did find other employment, we can look at the differentials between these two positions that the employee has had. Other issues concern pension. Lost pension, especially if it's as a state pension or a government pension, in other words, they're quite nice, okay, nice pensions. And the best way to compute these pensions are defined benefit pensions. They're very desirable compared to defined contribution types of retirement accounts or pensions, loosely speaking. The best way to go about computing loss of pension is what the employee would have received absent the incident had the employee retired properly at the point that the employee had expected to retire. So it would not be good. It would not be the most precise to use employer contribution to these defined benefit pension programs. No, the most precise and better way would be to use a present value of the payout that would have been received during retirement, which requires, some work, but it's not too difficult. Once you have been doing it a few times, the work requires some care, and some couple of assumptions. Other than that, that's the way to go. Present value of future loss of pension payout. What we need to do, of course, when we are computing losses is deduct losses, let's say, of benefits in both historic loss period as well as present value future loss period. We must deduct the employee's contributions to all benefits, including pension. So that's important. We don't do it when we're computing the loss of pension. We do it in the historic loss period and in the present value period. Okay, I do the calculation of pension loss separately. It's a little bit different timeline. The pension loss begins at the expected point of retirement, okay, compared with what depends on the storyline of your case, but we compare it what the person would have received in retirement with what this employee is now going to receive in retirement, meaning he was terminated early or left early, constructive termination, whatever the case might be. And the employee may still, if the employee was vested, receive retirement, but it be at a lower amount. And also, if the employee continued to work, absent the incident, the employee would have had a higher salary, presumably, at the point of the expected retirement. Hopefully that was clear. But as I describe in the outline, you need to, of course, deduct employee contributions in these pension programs. There is case law. Again, I'm in the last paragraph under pension above health benefits. There is case law, and I cite it there for you, where the diminished pension, because usually the defined benefit pensions are in public sectors, so that's what I'm referring to here. The diminished pension that the injured party is now going to receive can be considered collateral source and not used as an offset. And I give you these two cases, as you see before you. Mize-Kurzman versus Marin Community College District and Russo versus Matson. Okay, so that these public sector pensions that the injured party is now receiving cannot be used as an offset. Well, that's an interesting consideration. And in my reports, I do give this citation. But after these cases, there were some additional cases where the court rulings, appellate court rulings, may have weakened. Of course, I'm not a legal expert, but it appears that these two cases have been weakened to some degree. But I'll leave that up to you to research, okay? So it's still a consideration to bring up that these alternative pensions cannot be used as an offset. You can do two scenarios in the report. That's just what I do sometimes. One scenario is we're using the diminished pension as an offset. Another scenario, we're not using the diminished pension as an offset. Let's continue, please. Health benefits. Well, it's best to use the employer contributions to health benefits and offset those by employee contribution to health benefits. But as philosopher Jagger has said, we can't always get what we want. So this data may not be available or too much effort to get. Depends. You can ask for the data. What are the employer contributions? Sometimes COBRA statements can be helpful. Often pay stubs may have this, but not always. That's the problem. Not always do pay stubs have employer contribution. They may have employee contribution almost all the time, but not always employer contribution. So we need to get employer contribution. And it's not impossible to retrieve, but you need to perhaps in discovery ask for this in advance now that you know about it. But in lieu of employer contributions from the employer that's part of the case, we can use national averages again and still deduct employee contributions. If for some reason you don't have the employee contributions, your expert should duly disclose that this does not account for employee contributions. So we always need to be above board. To continue, Social Security, by the way, I should say, is typically not a loss, but more on that in a moment. I wanted to go back and have you review that the paragraph, the very last paragraph on page 8, where the employer cost per hour is part of the Bureau of Labor Statistics provides this kind of information. Different types of sectors are included, as well as whether it's union job or non-union. So we could use national averages, basically. You can use dollar figure or percent of salary. I've been using dollar figure as the national average. To continue, regarding documents and information used in valuing benefits, it's important to consider hearsay issues well in advance of trial. Hearsay issues in California, we have People versus Sanchez, and it's a relatively new case, last few years. And there are some workarounds, but again, this is beyond the scope of this course. Discussing Sanchez is important in California. To continue, another aspect that we could include would be recovery of these benefits through replacement cost. That's more expensive method because the party who lost the health benefits might be buying health insurance that is less in terms of benefits than what the injured party previously had. So it's very time consuming for your expert, for instance, to compare policy, apple versus apple. Okay, so, and usually is just not worth it. Okay, we can avoid examining that course of action, frankly. And that course of action, once again, is to review the benefits that the injured party had while employed and trying to find a policy out there that matches those benefits. And that's perhaps too time consuming. So focus on getting an employer contribution and discovery. Now, you can agree in these hearsay issues, both parties can agree to not bring up Sanchez. This is in California. And there's other workarounds too, but I won't, since many of you may not be practicing in California, I'll skip it. Except to say, you might need to bring in a human resource expert to testify that. So the Sanchez case may add some expenses if you don't discuss these issues with the opposing party. Social Security, I'll give you case law as well as articles discussing why Social Security should not be included as a loss. If the opposing expert brings in Social Security as a loss, that expert should deduct from that loss what the employee was contributing. Now, usually they offset each other. Employee contribution is offset by the employee contribution, so you're left with zero as a loss. Now, if they do bring in Social Security, that opens the door for the defense to bring in, well, gee, the injured party has been receiving, let's say, disability or some other form of Social Security, early retirement Social Security, maybe something like that. So it kind of voids the collateral source rule. But again, I'm not a legal expert. I'm just an economist. But this is just based on my experience in working about 1,000 cases and discussing and learning things, which I find fascinating in law. Okay, to continue. But there's other doctrines that discuss why Social Security should not be considered as a loss in employment cases and even personal injury cases. So I leave it to you to review. I give you the information. However, on the other hand, as a typical economist may say, when it comes to wage and hour cases, we should consider Social Security. What I mean by wage and hour cases, basically, would be misclassification of an employee. The employee was a 1099 type of employee, right? Rather than a W-2. And if the employee was labeled as 1099, for instance, like a self-employment, that employee was paying all of Social Security. So this needs to be considered. If the employee should have been a regular W-2 type of employee, then we need to factor in what the employer would have been contributing. So hopefully that was clear. Okay, so in those kinds of employment cases, factoring in Social Security might be useful and important. Unused vacation time should be considered. It's recoverable, especially for back pay. Okay, and it's a pretty easy thing to include. Vacation time could be valued at the salary that the wrongfully terminated employee was receiving. So that's about it for that. Okay, and to continue, we need to look at vacation time that extends all the way through trial. Now let's go to mitigation of loss. Well, typically, we can say generally, we need to deduct from losses any income that the injured party has made after leaving the employer that's part of the case. So that's kind of normal for experts to perform. However, there are cases where if the job subsequent to the one in which the employee was terminated was inferior, then perhaps that income from the inferior job should not be used to mitigate. And in California, we have a case, Via Corta versus Cemex Cement. And in other states, I'm not sure. But what is inferior employment? You would have to read that case. It could be travel time, of course, lower pay, different skills, lower skill levels involved. There were these factors discussed in that case. Anyhow, you can look it up if you wish. Inferior employment in this matter, via Corta versus CMEX. And anyhow, unfortunately, for plaintiff side, it appears, and again, this is beyond my purview, but it appears that this case has also been weakened a little bit by subsequent cases, this case being via Corta case. But it's something for you to consider, perhaps. Then, the comparable employment consideration, lots of case law on that. And I just give you a little bit here. I have more. I have a file, various files really, but one file is dedicated to comparable employment matters, just because it's interesting. And what constitutes comparable employment. But it's really up to the defense, as you know, at least in California, to prove that there was comparable employment out there that the employee could have gotten. But that is something to be handled by you. For me, all I'm saying is if I'm told not to include this employment because it wasn't comparable, then okay, if it's reasonable, I would go along with that. We do have a code of ethics in forensic economics that the assumptions taken must be viewed in a reasonable fashion. Anyhow, so inferior and non-comparable employment could possibly be used not as an offset, not to mitigate damages. So that's something to consider. But again, what is comparable employment? The case law spells that out. Well, repeating from a previous section, lifetime pay or work lifetime front pay is upheld by case law and FIHA, of course. And we could then discuss another matter that came to light below, where a female employee was denied a promotion because of gender discrimination, but because of no comparable position was available, she could not be made whole by staying on the job. So an award was given in this particular case. Post-resignation, back pay and front pay damages were viewed as proper. Then I discuss some collateral source rules, at least most of them are here in California, that I may cite. And I talk about how unemployment insurance and disability cannot be used as an offset. I'm sure all of you knew that. Disability and unemployment insurance. Now let's go to taxes. Well, what we're saying here is that taxes are really a non-issue for federal and state of California cases. In other words, future, at least according to what I understand, future income tax consequences are inadmissible, and plaintiffs are not required, according to what I understand, to produce personal tax records or returns. But the main thrust of the point that I wanted to get to, and work is still being done on this, it's a difficult issue, and that is the lump sum award given if you're successful at trial or in settlement may have potentially adverse tax consequences. This notion has been around for a number of years. And in the past, some courts found the computation of adverse tax consequences to be speculative. But one court, in a somewhat recent ruling, allowed for a gross up to be permitted to offset adverse tax consequences. In other words, you get a lump sum settlement, it's going to be taxed at a higher rate than the tax rate that is normal for your client, the wrongfully terminated employee, for instance. So we need to account for that. Well, it's a difficult job, and there is no method that is easy. And there are articles about this in our literature, forensic economics literature. However, there are some difficulties with that, just to be brief. We have to make some assumptions on deductions and so forth of the individual, of the injured party. So what I do, frankly, is just mention it in my report that these figures might be understated because I am ignoring the possible adverse tax consequences. There are other workarounds too that some attorneys have told me about, but I'll leave that up to you. All we're saying is a lump sum settlement would have an adverse tax consequence. To arrive at a figure would be many hours of work, what this adverse tax consequence would be. And perhaps in one court, I remember it was ruled speculative. I don't remember the case right now offhand. But again, it does seem this important case does allow gross up, increasing the losses to account for the adverse tax consequence. Now we get to punitive damages. Well, I don't have that much to say, but when the defendant is a private concern, and if the matter was egregious enough, you might be awarded punitive damages. So what the economist does in this case is compute, well, the financial ability of this company to pay additional damages. Without going into any elaboration, it could involve business valuation, but also we look at some other key financial ratios, such as liquidity and cash flows. But we won't go on too much on that. Another issue that could arise, and often it does, but I don't handle this. I do know of an expert that does, credit score damage. A wrongfully terminated employee who hasn't returned to work might be incurring a lot of debt and missing payments, etc. So the credit score could be diminished as a result of all of this. And this would impact your client's ability to get loans in the future and at good interest rates. So this can be considered, but I don't do this particular aspect of it, of economic loss, credit score damage, but it does exist out there. Just to rehash, what we were covering was economic analysis in employment cases. In our timeline, we're looking at back pay or historic loss and front pay or present value of future loss. The components of these losses include lost wages, lost medical benefits, and when we're speaking of health benefits or medical benefits, ideally we like to use that employer's contribution and subtract from that the employee's contribution. And then we have pension. If it's a defined benefit pension, which is really a lovely thing, we need to deduct from our benefits in total, the employee contribution to the pension. The best way to compute loss of pension would be the present value of the diminished payout, future diminished payout, because again, the employee might have been terminated early or constructively terminated and left before his or her expected retirement, and will still get a pension, but will be at a diminished amount. Some argue that this is can't be used, this diminished pension, to offset the pension that he or she would have received. But often I include both scenarios in my report. My reports are narrative friendly as opposed to Excel spreadsheets. To continue, then we were talking about what is the discount rate? Well, is that interest rate that we use to bring future values into present day terms. Okay. And there's wide latitude, as I mentioned before, in discount rates. Wide latitude the courts allow, and not much critique amongst experts. Then the wage growth rate. Some may use inflation rate, but I feel more astute to use a wage growth rate. And we need to employ a wage growth rate or some kind of growth rate to allow wages to grow into the future. That's also part of the legal standard. Social Security, unless it's a wage and hour matter, is usually not considered a loss. Simplistically, what the employer contributes to Social Security is offset by the employee contribution. And I provide case law and forensic economics literature substantiating this. Salary base. Well, we do want to account for any promotions that were part of the case, that this employee was denied promotion. So we do want to consider a scenario where the employee had he or she been granted the promotion, this is what the salary level would be. But we can also give a baseline that this is what the salary loss is had there been no promotion and no termination. So I tell you that we can find wage growth rates by looking at national averages. However, in some cases, especially public sector cases, we can obtain year by year the different wages. It's more time consuming, but it becomes a little bit more accurate for that particular matter. That there are salary schedules from year to year, both at local government, state government, federal government. Now it'd be okay to return to Treasury bills, perhaps. Treasury bills were very, very low in terms of yield for a number of years since the Great Recession. But starting last year, Treasury bills rose. So if we were to employ Treasury bills, the discount rate still would be low because of all those years prior to 2022 and between the Great Recession and 2021 for that matter, up to 2022, the discount rate would still be rather low. So again, the argument is the higher the discount rate, the lower the present values. There might be some push on that discount rate should have been higher. So be aware of that, but it's usually not a big issue. We had some questions arrive via email, and one question asked to do a hypothetical present value calculation. So I'm happy to perform that. Suppose the wrongfully terminated party was earning $50,000 a year. And typically the wages grew at the, let's just throw an example, 2.5% growth. So wages grew at 2.5%. And our discount rate, once again, the question asks exactly what does the discount rate do? It brings a future stream of dollars into present day terms, and which is a part of legal standard to do this. So let's say we have $50,000 as annual compensation. And then the net discount rate, let's say, subtracting from the discount rate, wage growth rate, let's just say it's 0.12, okay? Because that's a figure that I use for some of the present value cases that I have. So let's just say 50,000. I plug it into my financial calculator, 50,000 into the button called payment. And then it works like this even with an Excel spreadsheet. But $50,000 goes into payment. And then let's say this person had 20 more years of work life remaining. So I put 20 into N, and then the net discount rate, N being the number of years. I'm just focusing on the financial calculator. And 0.12 is our net discount rate. I plug that into a particular button on the financial calculator. And then I press the present value button. Okay. So you would think, for instance, that this individual who has 20 years to go of work life, and again, work life is just a statistical average given the person's gender and age and rate and gender, age, and education. So if we didn't do the discounting, we would see that 50,000 a year for 20 years is 1 million. But instead, we're using a discount rate of 0.12 net discount rate, and we arrive at a figure of 987,510 rather than 1 million. 1 million would be 50,000 a year for 20 years. That's $1 million. So instead, the discounting to present value would give us 987,510. So that would be the present value of $50,000 a year for 20 years, given a net discount rate of 0.12. Again, the work life, another question came in. The work life is just one, but required, in my view, approach. You could also include years to full age Social Security retirement. Typically, I do that if it's a little bit older worker. In the work life tables, by the way, typically I use median. Median means the 50th percentile, half work longer, half work less. So again, the work life tables is a requirement to use. But going back to the present value calculation, suppose we were to increase the net discount rate from 0.12 to, let's say, 0.5. So we put in $50,000 a year, and for 20 years. Now the net discount rate has been raised to 0.5, hypothetically. We now have the present value of this future income stream as 949,371. So again, it goes back to that point, the higher the discount rate or higher the net discount rate, the lower the present value. Usually these issues don't arise in deposition or even trial. Another question came about, and that is, how may an attorney engage the expert? Well, often we may list ourselves in directories, or there could be referral agencies as well. And usually I get an email or a phone call asking if I'm available, and sometimes just a couple of sentences about the case, not much. Then I may call, or they may call and reach me, and we talk about the case more broadly as well as more specifically. I ask for a complaint. Well, I also ask, what are the deadlines involved? It's so much easier if you engage the expert well in advance. Okay, and it usually pays out for the attorney to engage the expert in advance as opposed to last minute, which is stressful, an already stressful situation. I would ask for the complaint. Okay, so I can get a feel for the case. And then typically I send a questionnaire, my employment case questionnaire. Okay, that asks some demographic questions such as gender and race, education levels, etc. And importantly, the employment history and background, as well as pay history. Okay. And depending on the case, the analysis might require 8 hours to 12 hours. That would be the average range, 8 to 12 hours. Sometimes it may, to generate a report and become depot ready, sometimes it could be 20 hours, but typically 8 to 12. And especially if there's pension involved, that might definitely be closer to the 12-hour at least end of that range. I often ask for a retainer, but that's not important right now to discuss. Now, the documents that I ask for, and a good expert, in my view, would continue to pursue information. If the expert hasn't received, if I haven't received the information that helps me, I keep on pursuing. Okay, usually an employee handbook is not helpful. An employee handbook of benefits is not helpful. It doesn't give you employer contribution. And it's not that difficult to get employer contribution to benefits, but they should have that figure somewhere in the human resources department, one would think. So I ask for the responses to the questionnaire to come in a timely fashion. Sometimes I follow up. And then I ask for pay stubs. Sometimes it's important that we verify information on the questionnaire. Pay stubs, as well as W-2s. I may ask for a certain time period for the pay stubs and W-2s, but these do give us information, hopefully, that can be used. The pay stubs primarily, well, often they can have employer contribution to benefits. Typically, they have employee contribution to benefits, which need to be deducted. So again, the questionnaire is what I send off, and I ask for the complaint first, and then secondly, but more importantly, pay stubs, W-2s, any COBRA statements if they don't have the information about employer contributions on their pay stubs. There are other documents that the firm, the business, can provide that would include employer contribution to benefits. And you can ask for these in discovery in advance, preferably, because that's a must. If it's preferred to have this information that's most relevant than using national averages, but national averages are acceptable according to some case law. So I feel in preparation for a deposition, the attorney and expert should communicate, okay? And especially if it's first time working relationship, communicate about, well, what the expert sees as difficulties in the case, and really primarily questions that the expert anticipates and bring it to the attention of the attorney. Okay. And of course, the expert should only accept assumptions to be used, accept assumptions from the attorney if the expert believes that they are reasonable. You can't just use the assumptions just because the attorney asks you to. You need to kind of consider, the expert needs to consider whether there are reasonable considerations in the analysis. Usually with the responses to the questionnaire, I have follow-up questions, and often the attorneys are happy to seek out this information because they know that the expert is working hard on trying to make it as accurate as possible, it being the report, that is. So some preparation for a deposition, going over possible questions that the attorney thinks might be asked and what the experienced expert thinks could be asked. Now, if we want to pursue as precise as possible how salaries were increasing from one year to the next, let's say specifically in the public sector, because these are often published, then as in my experience, it might require 20 hours in total. Okay, we would look at salary schedules from year to year. From the point of termination, we can increase wages in accordance to this wage growth rate or to those salary schedules. So at the point of trial, which begins our present value of future loss calculation, we now have a salary that is different than the salary, a higher salary, than what the employee was last earning. So it's important to consider these things. I like going a little bit conservative into the report and let the readers know that the following aspects were not considered, so therefore the figure is understated. But generally working together, whether it's trial or depo, on what the possible questions are and what the responses could possibly be. Okay, truthful responses could be. So digging through the information and getting pay stubs and W-2s is really usually very straightforward and easy, and the employee should have them, and payroll should have these things as well. So that's not much of a problem. Well, I'm grateful for these questions from the audience, and hopefully they were helpful to all of you. I'm so happy that you were attending, and I hope that you learned quite a bit about what an economist does as an expert in employment cases. I'm grateful for your attendance once again. If you have any follow-up questions, feel free to send me an email or a phone call. Happy to answer any questions you may have. And good luck on your work ahead. Thank you.